Good morning. I hereby call to order the 17th meeting of the Pennsylvania Public Utility Commission for the year 2017. And today I will call up April Stover in observation of Veterans Day. April is part of our staff. She's a Marine Corps veteran, and she's going to lead us into today's Pledge of Allegiance. And to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, April. We will be having a special Veterans Day observance here in Hearing Room 1 immediately following today's public meeting, and we hope that you will be able to join us afterwards. So the first matter on this morning's agenda is the approval of the minutes for October 5th, 2017, and I recognize Commissioner Coleman as the editor.
Thank you, Madam Chair. I've reviewed the minutes of our October 5th, 2017 public meeting, and I move they be approved as submitted.
You have heard the motion of Commissioner Coleman to approve the minutes. Is there a second?
Second.
There's a second by Commissioner Sweet. Any discussion, any edits? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 4-0. And before we call up our Director of Office of Special Assistance, I do want to recognize we have two special guests today. We have two high school students that are joining us for today's public meeting, and they're part of the Project Dreams program that is developing. I'm going to have to ask Cheryl Walker-Davis.
I gave you my notes. I think it's developing relevant experiences and to promote meaningful skills in furtherance of career development.
Okay. The two students with us today, James Weatherhold from Mechanicsburg High School, and then we have Luke Capper, who is the son of Tom Capper, and he is from Trinity High School. If you could just please stand and we can recognize you. Thank you very much. So moving on to today's agenda, I will call up our Director of Office of Special Assistance, Cheryl Walker-Davis, and she will lead us through the agenda.
Good morning, Madam Chairman and Commissioners.
Good morning.
May it please this honorable commission, on behalf of your various offices and bureaus, we present for your consideration and disposition, commencing this morning with a binding poll. This is with regard to the application of Aqua Pennsylvania Wastewater, Inc., pursuant to Sections 1102 and 1329 of the Public Utility Code for approval of its acquisition of the wastewater system assets of Limerick Township. This poll is really a vehicle through which the commission will resolve the outstanding issues in the case in an orderly manner. It is just, and the sheets that have been provided are just a mechanism to facilitate that vote. The descriptions of the various parties on the sheets are not intended to be complete characterizations of the positions. Indeed, the commission bases its decision on the totality of the evidentiary record before them. The sheets that the commissioners have may differ from those of the public, and any omissions or misstatements or errors will have absolutely no effect on the outcome of this proceeding. With that having been said, we will commence with the first issue, that being the rate stabilization plan revenue allocation. Madam Chairman, before we move into that issue, I should note that Commissioner Coleman has a general statement that he'd like to make with regard to this proceeding, and I believe that Vice Chairman Place has a statement with regard to issue 8, which will be identified when we get there.
Commissioner Coleman, I call on you for your statement.
Thank you, Madam Chair. I just asked that my statement be entered in the record as though I read it in entirety. This is a conflict statement regarding Phil Kirshner, who is the newest member of my team. As many of you know, Phil worked for our Bureau of Investigation and Enforcement before joining my team, and just to avoid any impropriety, Phil has not advised me on this matter. Thank you, Madam Chair.
Thank you, Commissioner Coleman. So on the first issue, I get to call on Commissioner Coleman again.
ALJ.
Commissioner Sweet.
ALJ.
Vice Chairman Place.
ALJ.
And I also will be going along with the ALJ.
Issue number 2, rate stabilization plan, regulatory asset treatment.
Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Vice Chairman Place,
ALJ.
and I also will be going along with ALJ. We've got this song going on again, just in case you guys don't.
Issue number 3, rate-based valuation, ability to challenge fair market value appraisals.
Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Vice Chairman Place,
ALJ.
and I also will be going with the ALJ.
Issue number 4, rate-based valuation, HRG, that being Herbert Roland and Grubik, Inc., fair market value, income approach, income tax expenses, and discount rate.
Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Vice Chairman Place,
ALJ.
and I also will be going along with the ALJ.
And that, I should say, was issue number 4A. Issue number 4B, rate-based valuation, HRG, fair market value, income approach, going value adder, and provisions for erosion of cash flow.
Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Vice Chairman Place,
ALJ.
and I also go along with the ALJ.
Issue number 4C, rate-based valuation, HRG, fair market value, income approach, rate of return, rate-based analysis.
Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Vice Chairman Place,
ALJ.
and I also say ALJ.
Issue number 5A, rate-based valuation, HRG, fair market value, cost approach, reproduction cost of collection mains.
Commissioner Coleman,
ALJ.
Give me a moment. Commissioner Sweet,
ALJ.
Vice Chairman Place,
ALJ.
and I also say ALJ.
Issue number 5B, rate-based valuation, HRG, fair market value, cost approach, reproduction cost of land.
Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Vice Chairman Place,
OCA.
and I say ALJ as well. I mean ALJ because you were OCA. Okay. You're not going along with our song here. Come on.
Sorry. A wrench in the works.
Yeah, it's a
Issue,
welcome thing.
issue 5C, rate-based valuation, HRG, fair market value, cost approach, future capital projects.
Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Vice Chairman Place,
ALJ.
and I say ALJ as well.
Issue 5D, rate-based valuation, HRG, fair market value, cost approach, going value adder.
Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Vice Chairman Place,
ALJ.
and I also say ALJ.
Issue 6A, rate-based valuation, HRG, fair market value, market approach, customer count.
Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Vice Chairman Place,
ALJ.
and I'm going along with the company.
Issue 6B, rate-based valuation, HRG, fair market value, market approach, future capital projects.
Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Vice Chairman Place,
OCA.
and I will go with the ALJ.
Issue number 7A, rate-based valuation, Gannett Fleming, fair market value, income approach, 13-year terminal value.
Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Vice Chairman Place,
OCA.
and I will go along with the ALJ.
Issue number 7B, rate-based valuation, Gannett Fleming, fair market value, income approach, discount rates.
Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Vice Chairman Place,
OCA.
and I will go with the ALJ.
Issue number 8, noting the statement of Vice Chairman Place, public interest and affirmative public benefits.
Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Vice Chairman Place,
Thank you. I'm voting for the positions of OCA and I&E with my statement. Madam Secretary, I ask that my statement be placed into the record as if I'd read it in its entirety. I first want to commend Administrative Law Judge Stephen Haas for effectively presiding and exhaustively analyzing an adversarial and complex matter while permitting this commission to reach a comprehensive ruling within the specified 6-month timeframe. I also want to express my appreciation for the work of our advisory staff for delineating the numerous issues and the parties' positions in this proceeding. In my opinion, the synergistic operation of the applicable statutory sections of the Public Utility Code and the available evidentiary record do not support any form of approval for the present application and underlying transaction. The relevant legal analysis that is applicable here rests both on sections 1102 and 1103 of the Public Utility Code, as well as on section 1329 that focuses on the race-based valuation of municipal or municipal authority water and wastewater systems that are acquired by investor-owned utilities or other entities. Aqua Pennsylvania Wastewater Incorporated must demonstrate that the proposed acquisition produces net affirmative benefits in accordance with the requirements of Section 1102 and applicable court precedent. The existence of these net affirmative benefits involve not only the end user consumers of the acquired entity, but also Aqua's existing ratepayers. The available and credible evidence of record does not demonstrate the presence of net affirmative benefits on a post-acquisition basis for either the Limerick system consumers or the existing Aqua ratepayers. The alleged affirmative benefits put forward by Aqua are speculative and are not quantified. In contrast, the proposed acquisition will place large revenue requirements and rate increases on Limerick's customer base. Certain data indicate that these may be as high as $4.65 million or by a total of 105% over a 10-year period. If a lesser cost of the acquisition is shifted onto Aqua's existing customers, this revenue and rate increase burden will be even higher for the Limerick consumers. These detrimental effects will be created even if the Commission were to adopt a lesser rate base amount associated with the Limerick system acquisition and consistent with ALJ Haas's recommended figure of $64.4 million, which still produces an $18.2 million or 39.5% acquisition premium over the system's net book value. Furthermore, although the evidence of record indicates that the Limerick system is financially viable and capable of sustaining its own incremental improvements at the lower cost of capital of a municipal utility, such future investments will take place at the higher cost of capital, including a return on common equity capital and associated tax effects of an investor-owned utility, Aqua. I understand that Limerick wishes to sell its wastewater system and that Aqua is a willing buyer. However, this Commission has a statutory charge to carry out a proper analysis of the proposed transaction and ascertain with confidence whether it produces net affirmative benefits and serves the broader public interest. The evidentiary record clearly demonstrates that Aqua has failed to sustain its burden of proof in this proceeding. Therefore, I believe that Aqua's application should be denied. Thank you.
Thank you, Vice Chairman Place, and I will be going with the ALJ on this issue.
Issue number 9, imposition of 6-month statutory deadline.
Commissioner Coleman.
ALJ.
Commissioner Sweet.
ALJ.
Vice Chairman Place.
ALJ.
And I also will be going along with the ALJ.
Issue number 10, revised distribution system improvement charge tariff and long-term infrastructure improvement plan.
Commissioner Coleman.
ALJ.
Commissioner Sweet.
ALJ.
Vice Chairman Place.
ALJ.
And I also go along with the ALJ.
Issue number 11, 66 PACS Section 507 approvals, 20-day filing requirement.
Commissioner Coleman.
ALJ.
Commissioner Sweet.
ALJ.
Vice Chairman Place.
ALJ.
And I also go along with the ALJ.
And that was issue 11A. With regard to issue 11B, 66 PACS Section 507 approvals, prior filing of agreements.
Commissioner Coleman.
ALJ.
Commissioner Sweet.
ALJ.
Vice Chairman Place.
ALJ.
And I also will be going along with the ALJ.
And issue number 12, separate cost of service study.
Commissioner Coleman.
ALJ.
Commissioner Sweet.
ALJ.
Vice Chairman Place.
ALJ.
And I also will be going along with the ALJ.
Madam Chairman and Commissioners, that does complete the binding poll. The commission's poll results are akin to a vote. Staff will prepare a final order reflecting the results of that vote and ensure circulation and the appropriate approvals prior to entry before the statutory deadline. Continuing with the presentation of agenda items, turning now to page 2 of the public meeting agenda and matters on behalf of the Bureau of Audits, it is recommended that the Commission adopt the recommendation to release to the public the report involving the National Fuel Gas Distribution Corporation statements of low-income residential assistance, Rider F, over and under collections.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 4-0.
Turning now to matters presented on behalf of the Office of Special Assistance, commencing on page 3, it is recommended in omnibus fashion that the Commission adopt both items appearing on page 3, commencing with the one at the top involving the motion for default judgment of the Bureau of Investigation and Enforcement versus Metropolitan Emergency Services, LLC, continuing with the remaining item on page 3, the 2 items on page 4, and the first item at the top of page 5, that pertaining to the motion for default judgment involving Investigation and Enforcement versus Bridge Voice, Inc.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 4-0.
It is recommended that the Commission adopt the staff recommendation in the matter involving the complaint of Robin Callahan versus PECO Energy Company, noting the statement of Commissioner Sweet.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Under discussion, I recognize Commissioner Sweet for his statement.
Thank you, Madam Chair. The matter before us is the initial decision of ALJ Vero, finding that this commission is barred from granting a request for a payment arrangement to the complainant. The facts are that the complainant was granted 2 payment arrangements for her arrearage in 2007 and 2008, but those were for balances which were not paid but were later discharged in bankruptcy. ALJ Vero found that a balance discharged in bankruptcy does not erase the default of a prior commission-issued PAR, and therefore the customer is not eligible for another payment arrangement on a subsequent arrearage. While this customer has been the recipient of multiple payment arrangements, only 2 of them were issued by this commission. Under the restrictions of Chapter 14, the commission is barred from issuing additional payment arrangements if the customer defaults on a commission-issued payment arrangement. I agree with the ALJ that when a payment arrangement is paid off, the clock starts again, and the new balance is eligible for a new payment arrangement. I also, however, agree that a discharge in bankruptcy, which erases the arrearage that was the subject of a payment arrangement, does not have the effect of erasing the customer's default on the commission-issued payment arrangement. Accordingly, the decision of the ALJ is the correct one.
Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 4-0.
With regard to the complaint of Ivan Yotov versus Duquesne Light Company, there is the motion of Commissioner Sweet.
Is there a motion to call up this matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Under discussion, I recognize Commissioner Sweet for his motion.
Thank you. This case comes to us on exceptions to the initial decision of Administrative Law Judge Salapa, which granted the motion for judgment on the pleadings filed by Duquesne Light Company and dismissed the complaint of Ivan Yotov based on a finding that the complainant had already been adjudicated in a prior docket. The ALJ conducted an analysis which showed that the complainant's prior complaint was filed to require that Duquesne Light remove a tree from his property because it was dangerous. In the prior complaint, Duquesne Light provided sufficient evidence to support its position that the tree was no danger to the line, that the tree was located on Mr. Yotov's property, and that removal of the tree was his responsibility. That complaint was dismissed, and the time to open the record or appeal the Commission's action has long since passed. Mr. Yotoff filed the present complaint seeking to provide additional information to the commission, specifically information that he says has been excluded from the prior docket, or that had been excluded, from the prior docket as unsupported hearsay. The ALJ recognized that this is not a valid reason to allow another proceeding on the same subject and dismiss the second complaint. As to the application of the doctrine of res judicata here, I agree with the ALJ that the issues and causes of action raised by the complainant in the instant complaint and in the prior complaint are identical. In each case, the complainant alleges that the tree located on his property and near Duquesne Lights distribution lines is hazardous and should be removed by the company. The remaining two requirements for res judicata have also been satisfied: shared identity of persons and parties to the action, and the quality or capacity of the parties sued or suing. The pleadings in this case show there is no genuine issue as to a material fact with respect to the company's obligation to remove the tree on the complainant's property. Mr. Yotoff subsequently filed 2 photos of the tree with a paragraph which states, quote, "I am writing to request the record of the case be open so I can submit additional evidence," unquote. He goes on to reiterate the complaint's allegation that the tree is a dangerous tree. This is not new evidence. It is a restatement of the prior complaint, which is itself properly barred by the doctrine of res judicata, as well as Section 316 of the Public Utility Code. There is no evidentiary record to reopen in the second docket. Because the second complaint is already barred from being heard at all, the letter seeking that the record be opened would need to open the record of the first complaint. Obviously, the time period for reopening the record in the first docket has long since passed, as has the opportunity for appellate review. In short, the actions requested by Mr. Yotoff are time-barred and inappropriate for review now. Accordingly, the initial decision should be affirmed, the complaint dismissed, and the request to reopen the record denied. Therefore, I move that, number 1, the initial decision of the administrative law judge be affirmed. 2, the request to reopen the record is denied. 3, that the Office of Special Assistants prepare an appropriate order consistent with this motion. And 4, that a copy of the final order be served on the Commission's Bureau of Investigation and Enforcement, Director of Electric Safety for review and any action it deems to be appropriate. Thank you.
Thank you, Commissioner Sweet. You have heard the motion. Is there a second?
Second.
Second by Vice Chairman Place. Any discussion on the motion? Hearing none, all those in favor say aye.
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 Any opposed? The motion passes 4-0. On the matter as amended by the motion, is there any objection to taking the previous roll call? Seeing none, the matter as amended passes 4-0.
Continuing with matters on behalf of the Office of Special Assistants, now turning to page 6 of the public meeting agenda. With regard to the matter involving the PPL Electric Utilities Corporation tariff supplement pertaining to its rate schedule power service to electric propulsion applicable to Amtrak and the related Amtrak complaint, there is the motion of Commissioner Coleman as well as the statement of Commissioner Sweet.
Is there a motion to call up the matter for consideration?
So moved.
Is there a second? I will second it. Motion by Vice Chairman Place with me as the seconding person, whatever. I'm saying that wrong. I'm seconding it. So. It's been a long morning. With that, under discussion, I will call on Commissioner Coleman for his motion.
Well, thank you, Madam Chair, and I'd ask that my motion be entered into the record as though I read it in its entirety. This is a fairly complex case this morning, so I ask that you bear with me as I run through the chronology of events here just to provide some context to the case this morning. And I also want to thank Shane Rooney from my team for helping us navigate through this matter. Before the Commission are the petitions for interlocutory review of material questions filed by the National Railroad Passenger Corporation denying its motion to dismiss and a recommended decision of the Administrative Law Judge Salapa on August 23, 2017, dismissing the formal complaints in the case and granting PPL Electric Utilities Corporation proposed rate increase. I will be moving that the Commission deny the answers to the material questions in the petition and that the recommended decision be affirmed in part and reversed in part. On October 5, 2016, PPL filed a request to increase annual distribution revenues for the rate schedule power service to electric propulsion. The only customer that PPL serves under this schedule is Amtrak. The distribution service is provided through the Conestoga substation to Amtrak in Lancaster County. PPL represented in its filing that the substation required substantial upgrades to continue to operate in a safe and reliable manner. The proposed rate increase includes approximately $9 million in costs for capital improvements already incurred and approximately $14 million in estimated costs for future upgrades. Amtrak filed a formal complaint in response, asserting that the proposed rate increase was not just and reasonable. The history of this and prior proceedings involving these two parties and their rate schedules are complex. Many relevantly, Amtrak reached the conclusion during the case that it could repair, operate, and maintain the Conestoga substation for significantly less cost than PPL. Pursuant to that belief, it initiated an eminent domain proceeding against PPL for the possession of the Conestoga substation in the United States District Court for the Eastern District of Pennsylvania. Amtrak's enabling legislation does allow it to condemn property where necessary for further the purpose of its statute. By the operational law, the title of Conestoga substation passed from PPL to Amtrak with the filing of the declaration of taking and the positive estimated compensation to PPL on April 18, 2017. Subsequently, the district court issued an order on May 23, 2017, prohibiting PPL from making any alterations or upgrades to the Conestoga substation during the pendency of the condemnation proceedings. After the issuance of the court order, Amtrak filed a motion to dismiss the case with the commission, asserting that PPL no longer owned the Conestoga substation. This case should be dismissed for lack of jurisdiction. PPL filed an answer in opposition to the motion, asserting that it contesting Amtrak's taking in district court, and a district court had not yet ruled on the merits of the dispute. The presiding administrative law judge denied the motion to dismiss. Subsequently, Amtrak filed a petition for interlocutory review of material questions on June 13, 2017. Amtrak asked the commission to find that the ALJ erred because either one, the matter was moot or unripe due to the uncertainty over whether the upgrade work would be performed by PPL, or an alternative, the question of compensation owed to PPL by Amtrak has been preempted by the district court's order. While the petition remained pending, the rate case continued to be litigated before the commission. The presiding ALJ issued a recommended decision on August 23, 2017, that largely approved the requested rate increase and dismissed the formal complaint. No exceptions were filed by the recommended decision, but Amtrak filed a document in lieu of the exceptions in which it reserved the right to litigate these issues before the district court. Petitions for interlocutory review of material questions are generally not favored by the commission because the presiding ALJ had already issued a recommended decision on the merits of the rate case. I believe the petition is moot and therefore propose the commission decline to answer the questions posed. By dismissing the petition as moot, we must now address the recommended decision approving PPL's proposed rate increase. At the time of the proposed tariff and complaint were filed in this case, the commission properly exercises jurisdiction to resolve the contested non-general rate increase. However, the district court issued a valid and effective order prohibiting PPL from making any capital improvements, upgrades, or alterations to the Conestoga substation. If Amtrak prevails in the proceeding, PPL may never implement such work and will accordingly not need to recover any associated future costs. PPL would be able to litigate this issue of what it is owed by Amtrak for the taking of the substation and for the recovery of the $9 million in cost associated with the already completed improvements before the district court. Accordingly, I do not find that this proposed rate increase is ripe for decision on the merits. Therefore, I'll move that the commission affirm in part the recommended decision for the purpose of addressing the petition for interlocutory review on material questions and confirming the jurisdiction of the commission to address the proposed rate increase presented at the time of the filing in this proceeding. I also move that the recommended decision be reversed in part, as I do not find that the proposed rate increase ripe for decision on the merits. To protect the interest of the ratepayers, PPL is also instructed to track all costs it has incurred in the operating and maintaining of the Conestoga substation that Amtrak has not paid since the eminent domain proceeding commenced. Finally, I want to note my serious concern about the effect of the dispute on the provision of safe and reliable service to Amtrak and its customers. PPL has represented that the Conestoga substation requires a complete rebuild to operate safely and reliably, and it has provided uncontroverted testimony that Amtrak agrees with this assertion. I would urge the parties to resolve the matter as quickly as possible, whether through settlement or through expedited litigation schedules, so that the safe and reliable provision of the rail service to the public is not jeopardized. Therefore, I move that the recommended decision be affirmed in part and reversed in part, and the PPL's proposed request to increase rates be dismissed without prejudice, and the formal complaint of Amtrak is dismissed with prejudice. Second, that the commission decline to answer the petition for interlocutory review of material questions, and that the Office of Special Assistance prepare opinion in order consistent with this motion. Thank you, Madam Chair.
Thank you, Commissioner Coleman. You have heard the motion of Commissioner Coleman. Is there a second?
Second.
Second by Vice Chairman Place. Under discussion, I recognize Commissioner Sweet for his statement.
Thank you. I will not go through a recitation of the facts. Commissioner Coleman has done an excellent job of doing so in an accurate and thorough way. I have a little different take on what should be done ultimately here, at least ultimately as far as the PUC, because I believe this matter's hung on for many years, at least many months. And there is a certain aspect of this proceeding that ought to be decided and resolved in the manner that I'll outline very quickly. First of all, I do agree that the Commission should decline to answer the questions posed. As to PP&L's tariff supplement, PP&L presented evidence that it has already incurred over $9 million through December 31st, 2016 for upgrades to the facilities, separate from the planned upgrades not yet performed, which would cost an additional $14 million. PP&L provided substantial evidence to support its claims, and Amtrak failed to provide any evidence to counter PP&L's evidence concerning the need for reconstruction of the Conestoga substation, the method of reconstruction, the cost of the reconstruction, and the method of calculating the distribution rate. The recommended decision accepted PP&L's evidence and ruled in its favor. I note here, however, that the recommended decision provides that the requested rate take effect upon the completion of the upgrades of the Conestoga station. Since these upgrades are not permitted by the federal court order referred to by Commissioner Coleman, without the express permission of Amtrak, and will not occur unless and until PP&L is successful in contesting Amtrak's eminent domain efforts in the federal court. There is no legal bar to adopting the recommended decision. However, the eminent domain proceeding did change the nature of the investigation, and the recommended decision, while recommending a possible future rate, does not recommend a rate that is appropriate for the present circumstances as described by Commissioner Coleman. PP&L's evidence included the actual ownership of the substation until April 18, 2017, and the rate-making factors associated with the ownership of that facility up until that date. While the future of the substation is uncertain at present, title of the substation lies with Amtrak, which means that the evidence PP&L relied upon to support its claim is not accurate at this time. Accordingly, to adjust the claimed rate to one that is more accurate, considering the present change in circumstances, PPL should be directed to file a revised Exhibit SRK-7 that reflects the change in ownership of the substation, regarding the plant in service reduction and related adjustments, and to file a compliance tariff that adjusts its rate to reflect the current cost of providing service to Amtrak. This directive should be made with the understanding that if PP&L is successful in contesting the condemnation of the electric facilities and the return of the title to PP&L, it may file to restore the rates sought in this proceeding. The bottom line is that PP&L has provided and is continuing to provide certain services, and it deserves a rate that accurately reflects its cost to provide that service. Outright dismissal of the tariff filing does not result in such a rate, and therefore I respectfully dissent from the motion before us.
Thank you, Commissioner Sweet. Is there any further discussion on the motion? If there's no further discussion on the motion, all those in favor say aye.
Aye.
Any opposed?
Opposed.
Motion passes 3-1, noting the dissent of Commissioner Sweet. On the matter as amended, any further discussion? If not, is there any objection to taking the previous roll call? Seeing no objection, the matter as amended passes 3-1, noting the dissent of Commissioner Sweet.
Continuing now with the presentation of agenda items and matters on behalf of the Commission's Bureau of Technical Utility Services, commencing on page 7 of the public meeting agenda, it is recommended that the Commission adopt all of the recommendations appearing on page 7, commencing with the one at the top pertaining to the application of Columbia Gas of Pennsylvania, Inc. to abandon service to one customer in Clarion County, PA, continuing with the remaining items on pages 7, 8, 9, and 10 through and concluding with the item appearing at the top of page 10 pertaining to Peoples Gas Company, LLC, security certificate and affiliated interest agreement.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 4-0.
With that concluding the presentation of regular agenda items, we now turn to the carry-in agenda. It is recommended that the Commission adopt, on behalf of the Office of Competitive Market Oversight, the recommendation involving the operational issues and the implementation of PPL Electric Utilities Customer Assistance Program, Standard Offer Program, noting the statement of Commissioner Sweet.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Vice Chairman Place. Under discussion, I recognize Commissioner Sweet for his statement.
Thank you. Before joining my staff as legal counsel, Susan Kowa was working in the Office of Administrative Law Judge and worked on this case in her capacity as an ALJ. Please note she has not advised me in this matter.
Thank you very much, Commissioner Sweet. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 4-0.
On behalf of the Office of Special Assistance, it is recommended that the Commission adopt the staff recommendation that the Commission record and enter into the minutes of public meeting its action in granting, subject to further consideration, petition for reconsideration involving PPL Electric Utilities Corporation, Universal Service, and Energy Conservation Plan.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 4-0.
On page 2 of the carry-in agenda, it is recommended that the Commission adopt the Office of Special Assistance recommendation with regard to the Philadelphia Gas Works general rate increase proceeding, noting the statement of Commissioner Sweet and the oral remarks of Vice Chairman Place.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Under discussion, I recognize Commissioner Sweet for his statement.
Thank you. Before the Commission for consideration is the Philadelphia Gas Works rate case. A joint petition for partial settlement was filed with 2 remaining issues for litigation: the allocation of partial payments to customer bills and the recovery of costs for universal service programs. I share the concerns raised by the Office of Consumer Advocate regarding PGW's partial payment allocation process. OCA argues that PGW applies partial payments first to security deposits and late payment fees before applying the payments to the principal balance, which leads to interest being assessed on balances that have already been assessed interest. OCA states that this methodology results in interest on arrearages that exceeds the maximum amount of interest allowed to be charged to customers, therefore increasing the overall amount a customer must pay. I share OCA's concerns regarding the potential for the accumulation of interest on customer balances. The regulations at 56.22 specifically limit a late charge or penalty from exceeding 1.5% interest per month on the overdue balance of a customer's bill, and limits the simple interest rate on a per annum basis to not exceed 18%. As OCA notes, there is a possibility that PGW's managing of sequencing payments could lead to effectively imposing compound interest that exceeds the 18% annual limitation. Considering PGW may require a security deposit as well as a late payment fee per our regulations, I am concerned that the potential imposition of compound interest is both in conflict with our regulations and effectively overcharges a customer, especially when that customer is clearly already having trouble in paying his or her utility bill. While PGW should certainly be compensated for the cost of unpaid bills through late fees and interest, that compensation should not be excessive. Beyond being unfair, excessive add-ons are counterproductive in that the debt can become so large that for many, paying it off is nearly impossible. I also question PGW's process, as PGW itself argues that all basic charges under the regulations must be treated equally, while it then proceeds to prioritize partial payments to certain basic charges over others. However, I recognize that this issue is currently being addressed in a separate proceeding before this commission, and believe that process and that proceeding will aid in providing some direction to PGW and OCA. I strongly encourage PGW to work with OCA to address its concerns going forward to ensure that customers are in fact being charged the appropriate fees and levels of interest in a manner that is consistent with the Commission's regulations, orders, and the Public Utility Code. Thank you.
Thank you, Commissioner Sweet. Vice Chairman Place.
Thank you. I do wish to associate myself with the Commissioner Sweet's statement in this matter. In doing so, I want to emphasize that the proper allocation of partial payments to essential utility services for energy needs is beneficial to all ratepayers and utilities. Compliance with the Commission's regulations is fundamental in ensuring the continuous provision of essential utility services, as well as providing for payments of services rendered. I look forward to the continued discussion of this issue with the stakeholders in this proceeding. Thank you.
Thank you. Any further discussion? Seeing none, all those in favor say aye.
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 Any opposed? The motion passes 4-0.
It is recommended that the Commission adopt OSA's recommendations in the matters involving the Manwalamink Water Company's general rate increase proceeding, as well as the recommendation in the matter involving the petition for reconsideration of staff action involving the application of EMS Southwest, Inc.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 4-0.
Madam Chairman and Commissioners, that does conclude the presentation of agenda items.
Thank you very much. Before we adjourn today, there are a few important items that I want to mention. As you know, November is Critical Infrastructure and Resiliency Awareness Month. In case you didn't know that, it is. This month is designed to emphasize the importance of safeguarding our nation's critical utility systems against both cyber and physical threats. The United States depends on critical infrastructure every day to provide energy, water, transportation, financial services, and other capabilities that support our needs and our way of life. The security and resilience of this critical infrastructure is vital not only to public confidence, but also to the nation's safety, prosperity, and well-being. We must work together to ensure that our critical utility systems are safeguarded against a variety of challenges that continue to evolve, from natural disasters to aging infrastructure to man-made threats. Our responsibility as regulators is to understand and mitigate these risks, to protect our citizens, our communities, and our national security. Pennsylvania is at the forefront of these efforts to bring together key stakeholders in government, utilities, and nonprofit organizations to collaborate and prepare for these threats. And we continue to promote efforts to strengthen cybersecurity of key systems, to safeguard sensitive business and consumer information, and enhance the physical security of critical facilities and improve the resilience of these systems so that the services can be restored more quickly in the event of an emergency. Also this month, as we know, as we stated in the beginning of this meeting is Veterans Day that we will celebrate on Saturday. So we would like to bring to your attention, the PUC is very proud to announce a new initiative. As part of our observance of Veterans Day, we also will take part in a broader conversation about utility careers, and the PUC will join together tomorrow afternoon with a number of state agencies and utilities to recognize the importance and impact of veterans in our workforce. Our veterans have already made a tremendous contribution to keeping our nation safe and secure, and they also play a strong role in our public utilities and overall labor force. We depend on our utilities to help keep our communities safe and healthy, and it is important that we do what we can to ensure that our utilities have the skilled personnel they need to meet the needs of today and tomorrow. Again, stay tuned for more information about this. We will have information on our PUC website, as well as our social media channels and in the news, and from many of the utilities that are supporting our efforts. And we also want to thank Commissioner Sweet, who is also leading this effort in terms of veterans workforce, working with a task force with our national organization, National Association of Regulatory Utility Commissioners. So stay tuned for more information. I don't know if you have anything additional you wanted to add, Commissioner Sweet?
You've done quite well, Madam Chair.
Thank you very much. If there's nothing else to come before us today, as I stated before, we will have a Veterans Day observance after we gavel out of today's meeting. So with no objection,
Chairman.
Commissioner Coleman.
I had one other item I wanted to mention this morning, and this has been a matter that we have been working on as a commission for about 7 years now. This is the one-call law, and I just wanted to mention that last week, without great ceremony, the governor signed Act 50 of 2017, which is the one-call law that makes some very significant changes that we have been pushing for as a commission for a number of years, and that will move the enforcement responsibility of the one-call law to the commission. So I want to thank the governor for signing the legislation, and I also wanted to have a shout out for a true champion in this effort, and that is Senator Lisa Baker. We've been working with Senator Baker over the years, and she has done a fabulous job in getting this legislation to the finish line. This was a very, very complex undertaking. I think perhaps I was a bit naive at the beginning and not realizing just how complex this could be with all of the different parties and the interest involved. But the Senator did a fabulous job in negotiating a final legislative product that the governor has ultimately signed. So I wanted to give her a shout out this morning. And a special thank you to all of you in the audience and to my colleagues for your patience over the 6.5-year effort that we've put into this. And I'm delighted that we're now to the finish line and ready to move to implementation. So thank you all this morning.
We want to thank Commissioner Coleman for bringing that up to our attention, because we definitely do want to highlight and thank the General Assembly and the governor for this. But we also want to thank Commissioner Coleman. He's being very modest. He is the one that has taken the lead for the General Assembly those 6.5 years ago. So we want to thank him for all his hard work and effort in this. And we know that he's still going to be here to work on the implementation of that. So that's great as well. So thank you very much, Commissioner Coleman. And without objection, we are adjourned.